Hello and welcome to Edukemy's YouTube channel. My name is Harsh Singh and in this video we shall discuss the feature news for today, that is 12th of May 2022, which is on the sedition law. Is it justified, unjustified? What are the principles governing it? What are the judgments of Supreme Court? What has been the mandate of the government, and how it must be looked at during these times? Is it justified, unjustified? Just a bit. All right. I hope you're able to receive me. So let's begin this. I would like to start with one important comment, which is in favor of freedom of speech in the country. I disapprove of what you say, but I will defend to the death your right to say it. It has been spoken of by Voltaire. While this was spoken of years back, this is still relevant in India today. Why? It's because the constitution envisaged freedom of speech for everybody. However, having guaranteed freedom of speech in Article 19, they were also imposed some reasonable restrictions. For example, security of the state, integrity of the state. Similarly, public order, morality were some certain levels of reasonable restrictions that were placed. Now, sedition law happens to challenge the freedom of speech of the people. How is where I would like you to read some components of sedition law. Sedition law is not a separate law. It is a part of the Indian Penal Code. Indian Penal Code, IPC section 124A, and it mentions some things which I would like you to just read. Now it says, the sentence it says is, it defines sedition as whoever. Sedition in Hindi could also be synonymous to Deshdroh, Rajdroh. So whoever by words, either spoken or written by signs or visible representation or otherwise, brings to attempt to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by the law, shall be punished with imprisonment for life, to which fine may be added. Okay. So reading this part, making you understand some small parts. See, the idea behind explaining so much, spoken or written, by signs or by visible representation, the idea behind saying so much is that there are times when the authors have not said it verbally, but they have demonstrated through pictures, images, cartoons, and these are the visible representations. So they might fall under section 124A if it brings into hatred or contempt for against the government or the state. It excites or attempts to excite disaffection towards the government established by the law. That means we are not talking of India as a country. We are talking of XYZ party as the one ruling the state, right? So any disaffection towards that, not political entity, but the government of that day, that will also amount to sedition, Deshdroh, right? And shall be punished with imprisonment, or fine also will be added. Now this was the original scope of the article, right, under IPC 124A. However, a lot of amendments and interpretations have gone into framing this new judgment by Supreme Court, and now the country interprets the sedition law according to not just this but various other provisions included. One of them, the landmark judgment, being the Kedarnath versus the state of Bihar 1962. So before that, there are certain elements that also we must understand which are a part of this law. The expression disaffection includes disloyalty towards the country and feeling of enmity. Now I'll explain the provisions quickly while I give the examples. For example, Pakistan Zindabad, is that spreading disloyalty in India or not? That's a question. Demand for Khalistan, is it justified or is it seditious? There have been judgments on this, so we will discuss all that as well. Very interesting here. The second part, it says the comment disapprobation. Disapprobation means strong disapproval of the measures of the government with a view to alteration by lawful means without exciting and tempting to excite hatred will not constitute offense. And very similar thing written here again in the third part as well. So what they want to say is that if you want to criticize government, that is not a problem, but if you are spreading contempt or hate, if you are inciting violence, that will amount to sedition if you are doing this against the government of the day. Now this is what has been mentioned in IPC 124A. But let's understand what everybody else has to say, what the experts have to say in favor of this judgment, or in favor of removing a law like this, or against or having this law being placed at that same place where it is right now. What are justifications from both the sides? Let us understand. First of all, a quick background to what is happening these days is the sedition law is being considered by the government. Let's understand a quick background. Lately, a lot of cases have come up where IPC 124A has been picked up to put people in jail behind the bars, okay, calling them Deshtrohi, calling them seditious. So now, so many litigations have come up in front of the Supreme Court, and Supreme Court has asked the central government previously, a few days back, what is your stand on this? What is your statement on this thing like this when people say that this law is completely justified? So earlier, until now, the central government, the law commission, the parliament all have been endorsing sedition law, saying that this is no more a draconian law. We will understand why they say that. We'll understand that. So when they say that this is no more a seditious law, they should still be in possession of this law. When they say this is what they said. But right now the central government has said we will rethink on this. This is the latest, and this is where Supreme Court has said, fine, we will hold all the litigations that are happening. We will hear them after the central government has to say what amendments they are going to do in this particular law. Now we'll discuss the intricacies in a short while, but let us understand the opinion from the beginning. One side of the story is repeal this law, sedition, where if you just want to discuss critical issues about the government, if you don't agree with the policy of the government, and this statement is so vague to say what is spreading hatred and what not, so why can you not repeal a law like this? Because this is not applicable right now. We are just criticizing the government. So let us look at the beginning of this law. This law began during the time of codification of the Penal Code. Britishers' time, after 1857, the first war of independence, Britishers thought that we must codify certain penalty laws, penal laws. So one of the laws codified was on the sedition, and under this Mahatma Gandhi, Tilak, a lot of other people, Annie Besant, they were all imprisoned at some point of time, because they felt, the Britishers felt that their speeches, their writings were against the government of the day and spreading hatred against the government of the day. All right, they did that. But what about free India? So the thing about free India is right here. Gandhiji said, civil liberty is non-negotiable. It is like water. The reason we became free is so that we could be freely expressive, so that we could communicate our ideas freely, but with some reasonable restriction. That is what is the most important part. So the country which has from which we took this law, UK, has never used this law in the last 50 years. 50 years they have not used this law, and they abolished this law. And just in the year 2020, this law completed 150 years in India. It was formulated in the year 1870. So there has been a request repetitively, remove it, because we merely are indulging in exchange of opinions. We are just saying that you must consider this, right? We are not creating anarchy in the country. So this is what has been one of the arguments. The second is, there may be some people in the country who are speaking false statements about the past of the country. For example, 7 years back, one member of parliament spoke that Telangana, the part of Hyderabad and Kashmir, they were not part of India, and they were forcibly made the part of the country. Now this was factually incorrect. So is this a seditious statement or not? Right? This is where the response comes from the illuminates and distinguished jurists, that this is not seditious. The person is not informed well, and we must talk, we must discuss, we must debate all these things. That is what democracy stands for. We cannot call this Deshtrohi or seditious when any person is merely speaking false statements about the country. And if it places India in a negative light in the international arena, that must be taken care of differently, right? But people have the right to represent their point. This is important. See, this is where the idea here is, if certain provisions of the IPC 124A are being misused, suppose if the person has merely helped a person in need, a person who follows Naxalism, left-wing extremism, if that person was dying and that person only has been helped, does that constitute to a thing like sedition? No, it does not. So if one is placing these kind of people, for example, Binayak Sen, behind bars, just because they supported the Naxal person who was needy at that particular time, and that person has been placed behind the bars, It could be misuse of the law. I'm not saying it is. It could be misuse of the law. Supreme Court also, put a judgment on this, so we will understand that as well. Now, this is where, if the law is being misused at some places, does it mean we should completely do away with that law, or we should repeal that law? No, we should look at those checks and balances which should be placed so that the law is utilized well, so that people are made more aware, so that the government agencies are made more aware, and they are made more accountable. We cannot do away with the law just because there's some misuse of this, because there are provisions which are very much required for this as well. So while, now let us understand some parts of this. We will also discuss some elements like Bharat tere tukde tukde honge. Is it a right statement or is it seditious? We will understand if saying Khalistan Zindabad is against the integrity of the country or against seditious. We will understand if asking for a referendum in Kashmir is against the country or seditious or not, or Naxalism favoring it is seditious or not. So please remind in case I don't discuss this towards the end of the debate as well, because there are various sides of it. So let's understand. So the opposite side says that there is definitely a line between what is truth, what is the truth, and what is hatred. One must understand this line. And not only understanding this line, one must also understand very clearly that that causing dissolution of a state and disagreement with an opinion are two different things. So while we say for a statement like Pakistan Zindabad, Bangladesh Zindabad, that is still fine. But saying Bharat tere tukde honge, if somebody says it, this is against the state of India. This is spreading disharmony in the country. In fact, Kedarnath judgment itself said, we must discuss this very important judgment, it itself said that there are few parameters on which IPC 124A must be read. It must be read. So when we say spreading hatred, incitement of violence, or spreading enmity against the government of the day, this cannot be read alone. This has to be read with if it is inciting violence or not. One important thing. Or if it is creating public disorder or disturbing the public peace or not. So suppose if I said Bangladesh Zindabad or Sri Lanka Zindabad, however, this has not raised any eyebrow. Nobody paid heed to this. Nobody bothered about this. There was no public rage or protest against this. This is not inciting to violence. On the same ground, the court also gave acquitted people when people raised slogans for Khalistan Zindabad. Happened in 1995. Similarly, when we are speaking of suppose if we are speaking of a specific act like asking referendum to be held in Kashmir. Now there was a time where it was informally understood amongst the media people that if referendum was to be held, the people in Kashmir would want to create a new country for themselves. That would be the most preferred option. If this is United Nations supervised referendum, then it will have to be followed by India and Pakistan and Kashmir, all of them. And therefore, if Arundhati Roy raised a slogan saying referendum must be conducted in Kashmir, was it to the disaffection of state, inciting a violence in the country, or was it an intellectual debate? Did it raise violence? Did it incite any sort of public disorder or public peace? These should be the laid criteria for holding a person seditious or not, because there have been clear demarcations by the court saying that discussion and debate are different as compared to what was that? Yes, discussion and advocacy are different from incitement. So what is the provision under which I can discuss and debate the issue of referendum in the country, and what is the provision under which these stand as incitement of violence? So when people are being taken under these kind of sedition laws, then we have to understand what is the line between what is the line of discussion and what is the line of threatening the integrity of the state. So this is one thing to look at. There are people in the government, there are people in the law commission, there are people in the parliament, there are people in the Supreme Court, all of them saying that the law must stay. There have been repeated times it has been questioned whether the sedition law is constitutional or not. So people have said that there are divisive forces in the country as of now. There are people who want deshdroh, what you call in Hindi, that is definitely there in the country. So if we have provisions where we define what is the ambit of the law, if it has spread hatred, if it has spread violence, if it has ensured that public disorder is there or public peace is not maintained, in that case, please hold that person accountable under sedition law, otherwise not. So otherwise, if a person who is left-wing extremist and that individual is being helped by another individual, for example, Binayak Sen, just being helped because they are in need, that is not seditious, because this is not inciting violence, this is not inciting public disorder. But yes, in case it does so, then it is a problem, right? So this is how one must come clear on these kind of things. Raising slogan like Pakistan Zindabad is still fine, because if India has not declared Pakistan as its enemy, it is not disturbing the harmony, peace of the country. It is not disturbing the peaceful, the life in the nation. But in case India has declared Pakistan as an enemy state and we are raising slogans, then this is going to cause disharmony in the country. This could also be disloyalty towards the state and could also be under the sedition law. All right. So Kedarnath state versus state of Bihar very clear mentions that when you read IPC 124, you must acknowledge if there is violence committed, if there is public disharmony or public disorder or public peace, right? So keep on doing protests, that is not a problem. And be as much as critical against the government, that is not a problem, but do not spread violence, no public disorder and public peace. So if you remember, the protest by the farmers was peaceful as long as it happened in the Red Fort. The protest at other places like Shaheen Bagh, if they are happening peacefully, then it is fine, no sedition, but there have been provisions, there have been times when this has not been utilized well. Let us look at some of the examples. Have a look at this image. This has been this image was a cartoon which was depicted, not spoken of, but depicted by Asim Trivedi. And this was during not this government, but the previous government. So every government has utilized and misutilized the law, if you go by that literal meaning. So it says, national emblem, wolf with the sign of danger, Bhrashta Mev Jayate. This was a cartoon drawn against corruption. Do you find this seditious? Cartoon against corruption. This is the title. Asim Trivedi, and this person was put behind the bars on sedition law just because they wanted to make people aware about corruption, and they were hard against the government policies of the day, and they were against the corruption. But they were put behind bars on the charge of sedition. Similarly, if in Kudamkulam there is a peaceful protest of the natives of that place without inciting violence, without spreading any kind of disorder in the society, then is that under sedition law? No, that is not sedition law. But then again, it was misutilized. Similarly, there have been various cases, like alleged cases where Kanhaiya Kumar, Hardik Patel, Arundhati Roy, Binayak Sen, all of these people were put behind the jail because this was considered as sedition. Now, interestingly, the most interesting part is that court does not hold these accountable only as sedition. The court does not. The implementer of the law is who? The SHO, the ground level police officer, right? The ground level police executives who implement these laws, if they are not aware of what sedition means, sedition has to be read alongside the judgment of Kedar Singh versus State of Bihar. When they are aware, they will not be putting these kind of charges against people, because if one is conducting any kind of public, if somebody is burning the buses, if somebody is burning the tires, public property is being vandalized, there are acts for that as well. Disturbance of public property and Vandalism Act. Why are you charging them with such a grave offense, right? Desdrohi. This is a question being raised by many people. Similarly, it is not just the police people. There are some political motivations also. The local officers are never away from the political influence, and they are forced sometimes by the political authorities to impose such kind of draconian laws, right? But then this never stands the stand of the judiciary. This always fails ahead, in the test of judiciary, because we go by the due process set by the law, and it has very clear mandate. So the law itself is not draconian. Its implementation might need some tweaking, some improvement. This is where the Prime Minister also wants to say that during the Azadi Ka Amrit Mahotsav, we might want to have a relook at sedition law. It was not being relooked at since 1962. Imagine this. All the times it stood the scrutiny of Law Commission, the Parliament, the court, the petitions. But right now the government itself says that we will reconsider what can be done about this law. Okay, so so one should see what is the meaning of discussion, what is the meaning of debate, and what is persuasion to break the state. There is a difference between that. That only must be looked at, and this is how we must operate in these kind of laws, right? So while you look at another act like this, the IT Act of 2000, the IT Act 66A, one provision of this particular Act 66A was held unconstitutional. So it was removed. The IT Act itself has not gone, but the provision 66, section 66A of it was removed. And you know what was the part of this section? It said that it happened in Mumbai in the year 2015 when a couple of girls wrote Facebook statements, comments on Facebook, talking about the death of a political figure in Mumbai and criticizing that. And this was held as a provision under IT Act, under which these two girls were taken in police custody. So this is where the Supreme Court took the stand that this provision will stand removed in specific, right? Because the people have got the liberty to express their views, and if an individual is unhappy about it, nothing can be done, but people have got the ability to express their views. But the interesting part, even after that judgment by Supreme Court, many arrests were made under section 66A of the IT Act. Similarly, even when sedition is no more a draconian law, that is the reality. Experts, novice people say this. However, when still people are being put behind bars on sedition grounds, this is where people must be made more aware. This is where the law enforcers must be made more accountable for what kind of arrest they're making. This is where the amendments, or maybe some kind of amendments may be required, that the government only will tell right now what kind of amendment they are looking at. But then, unless and until the discussion, engagement, it threatens the security of the state, this does not come under the sedition law. It does come under spreading, maybe vandalizing the property and those other acts. There are many other acts which can be held accountable. Now, there's one thing more that you should note. There is also criticism of this particular process. Why? It is because while the Supreme Court said, what is your opinion? It asked the government. Government says that we will consider and we will let you know. Now, there are petitioners. They are waiting for some kind of, judgment from Supreme Court saying that this will no more be constitutional, this law. On the other hand, government says we will consider. Now, how much time they will take to consider, we don't know. And meanwhile, how many arrests will be made further on the ground of sedition law? This is what is the petitioner's concern. So petitioners say that Supreme Court, till the time the government is considering all this, you should consider all the cases coming to you. There should not be any cases which should be coming under IPC 1124A. This is what the petitioners say. But the Supreme Court has not straight away said this. Supreme Court says that the lower court will hear the request of the individuals. It will hear the request of the individuals who are charged with sedition law, and further see if bail has to be provided or if exemption from arrest has to be made, right? Supreme Court has also said that there will be stay on all the orders on any kind of judgment on sedition law. Now, this also involves there will be stay on orders. For example, if somebody has to be arrested, there will be stay on that order. However, what about the appellants? If people have been behind the bars and they are appealing, there will be stay on these things also. So right now, this present situation puts the petitioners and the people who are victims of sedition law at a very gray area. On the other hand, government has seek time. It says we would like to consider sedition law. However, when you look at sedition law, what you should do is look at the positives, negatives, and then arrive at the conclusion. Law is no more draconian. However, its implementation needs to improve. Law, when it was provided with the important court judgment of Kedar Singh. So that was the time when the law did not have any kind of negative teeth in this. So this is how you should approach. The conclusion to this is understanding the whole case of sedition, right? Sedition. So when you read sedition, one cannot read just 124A. One will have to read the Kedar Singh case 2000 and 1990, 1962. All right. One will have to look at the ways in which the constitution was formed in the country and the freedom was given to people. Right? We cannot divide people of speaking of what is the truth. We cannot divide of people talking about the state of affairs of the government. We cannot hold people speaking against the government. Criticism of the government, open criticism is justified of any government, and we cannot even withhold the rights of any individual, because that is what Free India stands for. But on the other hand, we will have to draw a line. We will have to draw a line, a balance of what is considered as seditious and what is not. What is considered as disloyalty to the nation, what is considered as provoking violence, what is considered as inciting violence, or having some kind of public disharmony, and what is not. So this is where the individual statements like Pakistan Zindabad, Bharat Tukde Honge, or Khalistan Zindabad, they must be evaluated. If it is not inciting violence, it is fine. It is a part of discussion, debate, demand, that is all fine, intellectual debate. So one must understand the difference between what is debate, what is endorsing a thing, and what is inciting. Endorsement is not inciting violence, right? Okay. So these are the lights in which sedition must be looked at. The provisions of the law, the positives, the negatives, whether it must be curtailed or not, and what are still the other issues. For example, even if the sedition law, so one more important part of is this, that even if the sedition law is removed, 124A is removed, what about the acts like UAPA, Unlawful Activities Prevention Act? What about acts related to National Security Act? These are also acts in which if people have been charged, bail is nowhere to be found. One will only keep running, the lawyers will keep running around the court to look for bail, but then the provisions are so strict that the police does not even need to seek any opinion from the accused. No need to gather evidences. These are the strict provisions of UAPA. So sedition, even if it ceases to exist, there are other laws under the garb of which the laws can be misutilized. So misutilization of law must be checked rather than removing a law which has got good intent. All right. Now this is where we complete an article like this. If you've got questions, please put it down in the comment section. And if you like this initiative, show some love through likes, comments and shares. We will quickly meet in another video for future news, that is on India-France relationship. Quickly to be covered in short. And let me see if there are comments. If you like this initiative, show some love through likes, comments and shares. Let's see. Nowadays, sedition is charged without understanding the complete context of words spoken. And yes, and that is the reason that any charge which has been put by the government of the day or by the executive, it does not stand the scrutiny of the court. In independent India, people haven't been charged with sedition. That's the case. However, people are going under trials because of this. So execution, that's the key. SC directed not to register any fresh FIR invoking sedition charges. Yes, SC said no fresh FIRs. But what about those people who are standing trials? What about the people who are requesting appeals? Everything stands at the place where they are, right? That is not giving justice to the people who are affected. Yes, Pakistan Zindabad, कोई फर्क नहीं पड़ता है in usual cases. So say Bangladesh Zindabad hai, Sri Lanka Zindabad, it's fine. But if we keep saying Pakistan Zindabad and if India has declared Pakistan as an enemy state, it does spread a level of disloyalty towards the nation. All right. So if Pakistan was a neutral state, it is fine. If it is not, then this is disloyalty, and disloyalty could be interpreted as amounting to sedition. Could. Criticizing the government is not anti-national. Be a part of the utmost levels of criticism, and you can see the criticism that was back in 2011 landed this gentleman Asim Trivedi in jail. However, criticism, this is where one must be strong, and one must make aware the executives and hold them accountable that criticism is not amounting to sedition. So now you people are aware. That's the most important thing here. Okay, all right. Thank you for participation. And if there are questions, offline viewers, please put it down in the comment section. We will ensure to get back. Thank you for participation. Let's see you in the feature news for India-France relationship. Thank you for